All right, class, let's settle down. Welcome to this crucial KSLU exam prep explainer. Today, we are tackling an absolute heavyweight in your property law papers. I'm talking about question 19, the direct mandate to write a note on charge and distinguish it from a mortgage. Now, this is a classic 16-mark university question, and let me tell you, tackling it requires absolute precision. You need statutory backing and a very rigid academic structure. We're going to dictate the exact anatomy of a top-tier answer today. So, pens ready? Let's commence.
Here is your answer blueprint, the exact chronological structure you must replicate in your exams. We'll be looking at the introduction and meaning, then the features and kinds, followed by rights, limitation, and an illustration. After that, we dive into a decisive comparative matrix for the distinction. And finally, we'll wrap up with essential case laws and a conclusion. Section 1. Introduction and meaning of charge.
Okay, first, let's read the text exactly as it appears. A charge is a form of security interest over property, but unlike a mortgage, it does not involve transfer of interest. It is governed by Section 100 of the Transfer of Property Act, 1882. Now, listen to me very carefully. In your answer script, I want you to draw a clear, underlined heading right at the center of the page before writing a single word of the statutory foundation. Presentation is just as vital as substance here. Write this introduction verbatim. The absolutely critical phrase here, the one you literally must underline in your exam is, does not involve transfer of interest. And honestly, never ever forget to underline the parent statute, the Transfer of Property Act 1882. Why? Because this tells the evaluator immediately that you know exactly which jurisdiction we're operating in.
Next, we move to the precise statutory definition, meaning of charge, Section 100. A charge is created when immovable property is made security for payment of money without transferring any interest in the property. Right, beginning your substantive answer directly with the bare act provision of Section 100 captures the evaluator's attention immediately. It proves that your legal knowledge is firmly rooted in the statute, not just some loose, vague concepts. Remember, the property is merely a security. The title, the ownership, the interest, they stay exactly where they are.
Section 2. Features and kinds of charge.
Let's read the features of charge. 1. No transfer of ownership or interest. 2. Created by act of parties or operation of law. 3. Gives right to payment from property. And 4. Enforceable by sale of property through court. Okay, draw your next major heading in your notebooks. Features and kinds of charge. We're moving from the doctrinal definition to the specific operational components here. I completely expect you to use distinct, unmerged bullet points in your exam, exactly like this, to ensure perfect clarity for the examiner. Notice the core mechanism we're talking about. If the money isn't paid, your remedy is strictly to approach the court and have the property sold. You don't own it, you just have a right to the payment extracted from it. Simple as that.
Now, the kinds of charge. On one side, we have charge by act of parties, which is created by agreement, versus charge by operation of law, created by legal provisions, for example, maintenance. I strongly advise the class to present this dichotomy clearly on your paper. Show the examiner that a charge isn't always some negotiated business deal. Sometimes the law itself imposes it, like a court decree for maintenance where a property is earmarked to ensure those payments are actually met. Laying it out like this shows a really comprehensive, structured understanding.
Section 3. Rights, limitation, and illustration. Let's look at the rights of a charge holder. Right to have property sold, and right to recover money from proceeds. Class, doctrinal theory is practically useless without practical application. Stating the rights of the charge holder is absolutely non-negotiable for a 16-mark question. Write these rights down deliberately. See how beautifully they flow logically from the statutory features we just discussed? Because no interest was ever transferred to you, your only real right is to compel a sale through the judicial machinery and take your rightful share of the money from those proceeds. Nothing more, nothing less.
But wait, here is the limitation. The text reads, not enforceable against bona fide purchaser for value without notice. Pay strict attention to this. I am giving you a stern warning right now. Skipping this single critical line will absolutely cost you marks in the evaluation. Mark my words. If a third party buys the property honestly, paying full value, and has absolutely no notice that a charge existed on it, well, the charge holder cannot enforce their right against that innocent buyer. This is crucial. It protects the sanctity of bona fide transactions.
And here is our illustration. A agrees to pay 50,000 rupees to B and creates a charge on his land. B can enforce payment through sale. You must provide an illustration like this. Writing down this concrete example basically proves to the KSLU examiner that you understand the practical, real-world application of Section 100. It shows you can translate a dry, bare act into a real factual scenario.
Section 4. Distinction between charge and mortgage.
All right, we have arrived at the absolute climax of this lecture. Let's read this matrix row by row. First basis. Definition. A charge is a security without transfer of interest. A mortgage is a transfer of interest as security. Second, transfer of interest. In a charge, no. In a mortgage, yes. Third, creation. A charge is created by active parties or law. A mortgage is created by active parties only. Fourth, right and property. A charge gives no proprietary interest. A mortgage creates an interest in the property. Fifth, remedy. A charge allows only sale through court. A mortgage allows foreclosure or sale. Sixth, registration. For a charge, it is not always required. For a mortgage, it is usually required. Seventh, scope. A charge has a limited scope. A mortgage grants wider rights. Okay, I command every student to take out your rulers right now and draw a strict tabular column in your notes for this. Listen to me. This perfect matrix matches the university answer key exactly. You literally must memorize these 7 absolute differences and reproduce them flawlessly in this exact tabular format to get those top marks.
Section 5. Case laws and conclusion.
Let's read these landmark case laws. First, Datatre Shankar Mote v. Anand Chintaman Datar explained nature of charge and rights of charge holder. Second, Kedar Lal v. Harilal distinguished charge from mortgage. Now, class, a bare explanation is merely a skeleton, right? Judicial backing is the flesh and blood mandatory to seal a top-tier grade in law. Pause your writing and listen to my deep breakdown of these authorities. In the Dattatreya case, the brief background dealt precisely with a financial claim tied to a property. The court laid down the absolute ratio decidendi that the fundamental nature of a charge does not create a right in rem, meaning a right against the property itself as an owner, but rather a right to secure payment. Its relevance to Section 100 is absolute. It completely confirms the no transfer of interest rule. Next, Kedar Lal v. Harilal. The facts here involved a dispute where the intention of the parties was heavily blurred. The court's verdict clearly distinguished a charge from a mortgage by stating a simple, unbreakable rule. If there is a transfer of an interest in specific immovable property, it's a mortgage. If not, it is merely a charge. Here's your ultimate exam tip. Write these exact case names in a separate boxed format in your answer booklet and underline them heavily. You want to immediately capture the KSLU evaluator's attention for a 16-mark answer. Force the evaluator to see that you have solid judicial precedent backing your theory.
Finally, the conclusion. Let's read it verbatim. A charge is a weaker form of security compared to a mortgage, as it does not transfer any interest. However, it still provides an effective remedy for recovery of money. This is my final, stern warning. Failing to wrap up your KSLU answer with this definitive summary will leave your paper looking totally incomplete and unprofessional. You've got to acknowledge the academic reality here. Yes, a charge is, doctrinally, a weaker security than a mortgage, but practically, it's a highly effective, court-enforced tool to recover exactly what is owed. So, as you prepare for your exams, ask yourself, when advising a future client on securing a debt, is the sheer legal weight of a mortgage always necessary, or does the simpler mechanism of a charge completely suffice? Think about that. Study hard, stick to the strict structure we laid out today, and I will see you in the next explainer.